Hello, everybody. My name is Sarah Smith. I'm here with Per Oscarsson, and we're here to discuss with you community property and characterization of property in Washington State. So all the property you acquire in life before and or after marriage has a certain characterization way that we treat it in Washington. And this characterization of property is important in a number of situations, including division of assets in a divorce, dispositions of assets upon death, even the creditor rights that creditors may have against the property that you own. Community property, term you may have heard before, is a principle of law that applies in Washington and a handful of other states in the country. And this type of property includes all the property acquired and held jointly by two married spouses or domestic partners, with some exceptions, over the course of their marriage. And for the purpose of this lecture, I'm just going to use spouse to cover both spouses and domestic partners. So community property includes all of the employment earnings and assets that are acquired during the marriage and are held in the name of both spouses, and the assets acquired during the marriage that are held in the name of both spouses. So examples of these are wages that you earn, rent from property that you purchased with community property. These can be benefits that you acquire from your job during the course of the marriage, all of these sorts of things. And community property can be earned by one spouse or managed by one spouse and still be jointly owned by both. The classic example of this being a married couple where one spouse is staying home and taking care of the house and the children and managing affairs, while the other spouse is going to work and holding a job and producing the income itself. And what this does is it makes sure that both spouses are protected and seen as contributing to the marital household as a whole. Community property, as I touched on, can be managed by just one spouse, but there does need to be agreement, either explicit or implicit, about how that community property is disposed of. This doesn't mean that one person is double checking every grocery list or every gift that's given to family, but there really shouldn't be anybody running off and buying a private island secretly either. You should also be aware, it might not apply to you, but if you are moving here from another state that does not have community property laws and you acquired this property during the marriage, it does not automatically become community property just because you moved to Washington. As Carol discussed later, this is where community property agreements or other arrangements may be beneficial to protect your spouse's interest in your marital property. Now I've just spent a little bit of time talking about community property. So then what's separate property? Well, separate property is going to cover the property that you owned prior to getting married, as well as gifts or inheritance or things that you receive separately, even while you're married. For example, one of you may receive the family heirlooms from your parents, and that is left to you specifically, then that becomes yours, not part of the marital community property. These distinctions matter, as I mentioned earlier, because you have the rights to give those things. If you come and see us about your will or an estate administration, you hear us talking about probate and these sorts of matters, this becomes incredibly important because you have a right to give all of your separate property as you see fit. But you as a married partner only have the right to give away half of your community property, of the marital property, the other half being owned by your spouse. And if there is no will and there has not been estate planning, then that community property vests automatically in the surviving spouse. So if there is a desire to keep separate property and community property separate and protect that characterization for whatever purpose you may have, it's incredibly important to keep good records because separate property will continue to be treated as separate property after the marriage as long as it can be clearly traced and identified. Separate accounts, receipts, documentation. If that separate property and community property becomes so commingled and enmeshed that it becomes difficult or impossible to tell what is what, then everything becomes assumed as community property. The classic example of this being bank accounts. You have a bank account prior to your marriage. Afterwards, both of you take all of your separate monies and put them together into a single shared bank account. Well, at that point, it becomes incredibly difficult to tell which funds are community, which funds are separate, especially over the course of years of marriage. And so the assumption will be that all of it is community. Conversely, if you have a separate rental property that you acquired prior to marriage, and the rent is kept into a separate bank account, and the expenses are paid from that separate bank account, and the whole situation is kept separate and clean, well, then it's easy to show that this is in fact separate property and remains separate property over the course of the marriage. Generally, property acquired will be assumed community unless documented. But the other exception is also if the spouses agree to change how that property is characterized and make a written enforceable agreement to change that characterization. Examples of these documents, Per will now discuss.
Thank you, Sarah. One thing I wanted to clarify too, though, is with domestic partners, Washington has a state-registered domestic partnership where you actually register the union, if you will, of two adults, at least one of whom has to be 62 years of age. And the law in Washington for community property will apply to partners in such a partnership. And for marriage, it also applies both for marriage between a man and a woman and same-sex marriages. So I'm going to, as Sarah did, I will talk in terms of a spouse and mean all of those. There's also something in Washington, here in Washington, it's called a committed intimate relationship that goes by other terms in other states. It went by other terms in this state for many years, but it's now called a committed intimate relationship. It could be a partnership between two adults, but they don't qualify to have a state-registered domestic partnership. In those cases, what I'm going to talk about will not apply because there is no ability to have community property under those circumstances. One of the ways that to be creating community property, at least as to real estate, is to do it by deed. So for example, one spouse comes into the marriage with a piece of real estate. It's owned entirely by them. But after they get married, that spouse could sign a deed that conveys their interest to themselves and their spouse as community property. So that has the effect of converting it from separate into community property. There is, of course, a recording fee to do that, but although real estate excise tax would typically apply on a transfer of real estate, there is a specific exemption when a couple is either creating or separating community property. Another way, and that was one of the ones that Sarah alluded to, is the community property agreement. We typically think of them as a two-prong or a three-prong agreement. The two-prong agreement says everything that each party had as separate property before the marriage will now be converted or treated as community property. The other prong there is that everything that either party receives during marriage, which would pick up gifts and inheritances by one of the parties, by one of the spouses, that will also be treated as community property. The three-prong goes one step further and says, whatever community property the parties have, upon the death of the first spouse, the second spouse will receive all of it. That goes counter to what Sarah was talking about, that typically a spouse can gift, or at least with consent, they can gift up to 1/2 of the community property. They can bequeath up to 1/2 of the community property. They cannot bequeath their spouse's interest in any community property. So a community property agreement can override an inconsistent will. Now, that's not to say that spouses should not have a will anyway, because if, for example, they have only a community property agreement, one of them dies, the community is now ended, and the other spouse, assuming it's a three-prong, the other spouse has all of the property. But if they don't have a will, what happens when they die? Then we end up with an intestacy, and we have to go to state law to determine who gets property. Community property agreements can be useful at different stages of life, and maybe more useful or less useful depending upon where someone is in their life. And that's something that should be discussed with the planning attorney when you meet with them. For example, maybe a young couple, it may be appropriate to have a community property agreement. If very young, they may not have much property coming into the marriage. And they may or may not receive gifts or inheritances, and may not even anticipate receiving any such things. But a community property agreement may be appropriate in that circumstance. It may or may not be appropriate, for example, in a second marriage, particularly if there are children from the first marriage. If there is a community property agreement in the second marriage, it could end up that the children from the first marriage receive nothing. And of course, that may be the intent, but it's something that should be considered in the planning process, because it may inadvertently result, if the two spouses in the second marriage now enter into a community property agreement that particularly says everything is going to be community property and it's all going to go to the surviving spouse. That could have the effect of completely eliminating anything for children of the first marriage. Another consideration as people get older is qualifying for certain governmental benefits. There may be some things where what you have may disqualify you for certain benefits, medical or otherwise. And with the existence of a community property agreement, it may be much more difficult, if not impossible, again, depending upon the circumstances, to qualify for those benefits. I think as Sarah also mentioned, the surviving spouse does not necessarily receive the deceased spouse's interest in community property. Because, for example, in a two-pronged community property agreement, all you've agreed is that what you have is going to be community property. You haven't agreed what's going to happen to it. That would still leave open the possibility for a spouse to sign a will that disposes of some or all of their one-half interest in the community property. It can also happen if there's no community property agreement at all. One spouse could give up to their one-half interest. I had a case many years ago where I represented the husband, long-term marriage, 45 plus years, but they were living separately because of health issues. And so I did not do any work for the wife. And the wife died first. And when we found her will, which the husband did not know had been signed, said, I recognize that my husband has a one-half interest in the community property. So I'm not giving him any of my interest. I'm giving it to 12 other people. Came as quite a surprise to my client that she was giving her interest in all of the community property, which was almost entirely community property, to other people, family members, nieces, nephews, cousins, etc., but not to the surviving spouse. Again, if there's no community property agreement and no will, then we have to go back to state law as to where the community property is to be distributed. And if there's a surviving spouse, the surviving spouse receives all of the community property. If there's separate property, it will differ depending upon who the survivors are. It doesn't say who gets what property of that, but it does say who is to receive whatever there is, or an interest in it, and it's usually a fractional interest, which can mean that you could have several people having a fractional interest in property. again, that's separate property, not the community property. That's about all I have for our agreements. As I say, one of the things I was not going to talk about a great deal, and I won't, but did want to just touch base on the committed intimate relationship. It would be possible for participants or the parties to that committed intimate relationship to make an agreement as to who owns which property. Now, if something were to happen on the family law side in a separation of their interests, then the court looks at the equities of the situation. But there's no community property, separate property consideration because those concepts don't apply. Now we'll just see if we received any questions from our audience.
Doesn't look like it.
I didn't think I saw any.
I guess we did such a good job. No one has anything to follow up.
No one has
with
any
us.
questions.
Oh.
Uh-oh, got a question.
So it says, Pear, I know it's standard when doing an irrevocable life insurance trust to partition the community property to create separate property, but couldn't the parties simply agree to convert to separate property?
I think they can still do that. Certainly with the real estate, there's no problem doing that with a deed between the parties. I haven't seen it happen all that often, but the process is still there to do that. And it seems to me that they would have the ability, if they can do the community property agreement to create community property, which otherwise wouldn't be, then it seems to me that they also have the ability, although it may not be called a community property agreement, I've seen them also titled as a status of property agreement, that they may be able to do that anyway to separate out. I hope that answers your question.
And do we have any other questions?
Don't think I
Doesn't
see
look
any.
like it. So if anything else comes up later, you are welcome to call, email. We're always happy to help and answer questions that might arise. Otherwise, we'll see you next time. Thank you so much for coming.
Thank you all.